Good day, Crime Talk aficionados. We have another big show for you today. First, why does Bryan Kohberger not want us to know his shopping habits? Karen Reed's hearing gets a little contentious. Don't have knives around this woman if you're going to end a relationship. Give people drugs and those people die, you're probably going to go to prison. Officer Sexy was arrested. And guess for what? We have this day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get to the docket, remember, go to crimetalksearch.com if you have not already done so. Sign up for that background subscription service, which you can cancel at any time. But when you have that subscription, guess what? You can do as many searches as you desire on anyone here in the United States. And you type in the person's name, you narrow down some information, a report is generated, literally emailed to you while you wait, and you can request to get updates if any of that information changes. And you're going to get all the information that you could possibly desire on an individual. What's their social media presence? Do they have liens? Do they have judgments against them? Do they have a criminal history? Are they on one of those registries we hear so much about? Yes, go to crimetalksearch.com and find out. You're going to be happy you did. All right, let's go ahead and get straight to the docket today. It is Thursday, March 6th, and we did a big show yesterday. I don't know, maybe I need to do all my shows for an hour in depth like that because there was a big response. We appreciate that. We have a little more information. I told you there were a lot of motions filed in the Bryan Kohberger case because the judge said, hey, not everything needs to be sealed. None of this stuff is particularly bad. And guess what? It's all going to come out at trial anyway, which people are going to see. And a lot of this information is already public. So what's the big deal? So basically, they unsealed all these documents and we got to see what the case is boiling down to. Now, yesterday, we brought you the whole issue about, whose DNA was under Madison Mogen's fingernails. You know, inconclusive means not saying it is, not saying it isn't. It just simply means, guess what? That there's not enough of the DNA sample for them to make a match as it relates to enough of those alleles in the DNA profile when the lab does their stuff. I think we explained it pretty well yesterday as it relates to likelihood ratios and things of that nature. It's theories and statistics and all that kind of stuff. And we all know, depending on which side you're leaning towards, so to speak, there's lies, damn lies, and statistics. And it depends on who's coming up with those numbers. Anyway, I don't think that is going to be excluded. I think the prosecution is going to be able to talk about the inconclusive DNA results because it goes to what they did to try and get information in this particular case. And obviously the defense is going to try to attack the prosecution and the way the collection of evidence was handled. So therefore, they, being the prosecution, are going to be allowed to show what they did in that process. But let's talk a little bit more today about why the defense doesn't want us to know about Bryan Kohberger's shopping habits. Could that be the figurative smoking gun, or maybe the sharp blade of a K-bar, perhaps? Well, we're going to have to wait for trial to see, but I think it's going to be very key. So Bryan Kohberger is asking the court in his case to exclude evidence of his Amazon purchase history and other activity on the shopping site from his upcoming trial in the deaths of those 4 University of Idaho students. Now, defense attorneys argue in their motion that no Amazon evidence, including click activity on the app, should be introduced at trial, partly because the term is vague and the prosecutors have allegedly failed to define it or describe the nature of the expert testimony prosecutors want to introduce. Now, the defense asserts that with the limited disclosures made by the state thus far and a lack of raw data, which is a lack of complete data, lack of disclosure of experts' opinions, and lack of explanation of Amazon click activity or any analysis related thereto, amounts to cherry-picking limited data that does not show a full picture compared to warrants that requested extensive data, is what the defense is arguing. So, what does that mean? Oftentimes, say, for example, when there is a dump of information, say, for example, a cell phone, there's lots of data, but you're only going to present what's relevant, right? Under the rules of evidence, has to be relevant. What element does it go to prove or disprove as it relates to the charges? If the evidence doesn't go to prove or disprove a particular element of the charge, it's not relevant. I'm going to go on a limb here and say what is relevant here is going to be the purchase of perhaps a weapon that could have been used in the deaths of those 4 college students. Now, it gets a little more, interesting. All right. Listen, I have no dog in this fight. I love seeing good lawyering. It's like watching a good football game or hockey game. It doesn't matter. You just like seeing good lawyering. All right. And the defense is doing good lawyering. But let me tell you, I've explained this before. Motions in limine are the defense's request to limit bad evidence, prejudicial evidence, or evidence that they believe is completely irrelevant. The standard for relevance is, like I said, quite low. The prosecutors can often tie that up together rather quickly. But I went back through the motion, so you all didn't have to, and their motion to exclude Amazon click activity evidence at trial. And I think it's worth noting here, all right? The state has not defined Amazon click activity in any report or expert disclosure, nor provide any opinions or analysis related to the limited data it has produced. The data produced is extremely narrow when compared to the more inclusive and broad warrants and subpoenas, even in the face of the court telling the state that its job was not done with the expert disclosures. Nothing was produced in the state's rebuttal expert disclosures or further clarifying the underlying information. I'm not sure why this has to be expert testimony. They could simply bring in somebody from Amazon that is familiar with their system and explain what these business records tend to show. So I think they're getting over their skis here a little bit, and I don't think the prosecution needs to endorse somebody to explain the click activity as to how it went place. You just simply have to have somebody that can lay the foundation, bring those records in, and then you could have just an agent who's familiar with it explain what went on. It'd probably be better if you had somebody from Amazon explain that as well. So anyway, in the evolving age of technology, the defense argues, Amazon uses artificial intelligence to improve the customer experience by helping customers find products that match their interests and preferences. Amazon AI-driven system does not just reflect searches, it actively shapes users' behavior through recommendations, paid advertisements, and algorithmic reinforcement. Amazon use of AI began well before 2022. Often when searching for something on Amazon, the end of the pathway does not tell the beginning of the pathway. This is because AI is continually gathering information about the customer's interests and preferences and making suggestions. Customers in the context of a household sharing an Amazon account is all members of the family sharing this account. In other words, the purchases, searches, and machine learning impact are all of those of the same household account through Amazon. Anyway, in 2022, Amazon's AI-driven system did not passively reflect user searches, but actively guided purchase behaviors based upon predictive models. This means the user's browsing and purchase history may not necessarily reflect deliberate intent, but could have been shaped by the algorithm. In this case, the state's refining or limiting the Amazon click activity to a specific click or a specific item excludes data, takes things out of context, and could tell a completely inaccurate story to cause the jury to speculate about intent. Full Amazon advertising logs and recommendation data must be reviewed to determine whether a purchase was truly initiated or heavily influenced by Amazon's AI. The data produced does not identify the purchaser through means other than by name or credit card, nor does it identify the device from which the item was purchased. For example, suppose somebody buys a pair of binoculars on Amazon in a household account with 4 users. Who is the household? Either search for binoculars or through some other search-triggered Amazon AI. How long were they searching for the binoculars? Were they a wish list for a period of time? Were they placed in the cart and removed, all which indicates indecisiveness? Were other ads shown to the purchase by Amazon? How long were the binoculars searched before being actually purchased? What types were considered or placed as target ads by Amazon? Were other purchases made? Other purchases made around the same time provide context to the intent of the purchaser. In our example, the shopper also purchased a sleeping bag, a tent, a cook stove, long johns, and safety vest for an upcoming hunting trip. Compare the possibility of the purchaser instead bought rope, night vision goggles, zip ties, duct tape, and a stun gun. Those combined purchases could show a completely different intent. The Amazon clicked activity in this case for an account which is a household account shared by Mr. Kohberger and other family members. This click history includes items searched for or viewed on Amazon, which might be related to a search conducted by other family members, which might make the items being suggested by Amazon. Therefore, Mr. Kohberger believes that the state intends to use Amazon evidence to prove elements of its case. To allow such in the face of an explanation above and the failure to disclose would be unconstitutional and violate the rules of evidence. They have records from Amazon. It's going to show who's on the account. It's also going to show where items were shipped from. If they don't have IP addresses, somehow I think they do. But the point is it's relevant, and they're going to use it to try and prove an element of the offense, perhaps a deadly weapon, planning, modus operandi, those types of things. I think it is going to be significant evidence. Yes, obviously the DNA will be significant, but also consider shopping lists. When you're preparing, allegedly, to go do something, we'll give Bryan Kohberger the presumption of innocence. But remember, you filed those motions because you want to keep something out because it's bad for you. Ladies and gentlemen, remember that. A couple of other motions just very quickly that we didn't go over yesterday. State's motion limiting regarding AT&T timing advanced records. The state brings this motion based upon defense counsel's repeated reference to the alleged existence of AT&T timing advanced records related to the defendant's cell phone. See defendant's supplemental response regarding expert witnesses, defendant's exhibit D11. B, page 49. Defendant's Exhibit D14, page 4 through 5. The state has been advised and will offer documentation and or testimony that AT&T records are produced by their Global Legal Demand Center, GLDC. AT&T, GLDC, did not begin producing timing advanced records until May of 2023. All records for defendants' phones were obtained from GLDC in December of 2022. The state intends to supplement this motion with additional information from the FBI and or AT&T prior to the hearing on April 9th. Any statements or inferences by the defense counsel of their witnesses that there is additional evidence that could have been provided or was not provided is a mischaracterization of the evidence and should not be allowed. Any probative value of such evidence outweighs the dangers of misleading the jury. Yes, the 403. Basically what they're saying is, hey, the timing, you got to do the UTC from when, the timing starts on the phones and add 6 or 7 and subtract 6 or 7, all those types of things. That's what that is getting around to. And the defense is trying to say, well, the timing's off, so therefore there's missing data. No, it's because they changed their system, and so they'll have to do that. There's a motion to allow victims in the courtroom, defining who the victim is under the statute. As you may recall, we ran into that under the Lori Vallow matters. And also, the state wants to limit the defense from making any reference that the state is attempting to kill their client. I mean, everybody's going to know it's a death penalty case because the jury is going to have to be death qualified. What does death qualified mean? It simply means that before you can sit on a case is going to be a death penalty case, that the jurors have to be able to say, I can impose the ultimate punishment if we get to that particular phase. So if Bryan Kohberger is convicted, I am willing to impose the death penalty. Obviously, they don't have to, but they have to be able to say, yes, I'm willing to do that to be selected for the jury. The next motion is that the prosecution wants the mention of IgG, the investigative genetic genealogy, limited because, as we've heard about, it's been ruled on. There's no errors that were made by the prosecution, at least according to the judge, as it relates to this information. Nothing nefarious. It was simply a tip. They used it to do that. But apparently the defense wants to go into it further, and the prosecution doesn't want the defense to be able to mention the fact that the FBI violated their own policies not a rule, a policy, and that it may not comport to some sort of other international standards. That will probably be granted. There'll be a little bit of leeway, but they're not going to be able to get into that. Now, here's another thing that's going to be interesting, is that the state's motion in limine regarding admissibility of demonstrative exhibits and memorandum in support thereof. Now, what they are saying is that obviously the court has great discretion regarding demonstrative exhibits, and a diagram offered for demonstrative purpose need only be relevant to illustrate a witness's testimony. It does not need to be precisely accurate. A demonstrative exhibit could be somebody going up there and drawing a square and saying this is a room and this is a hallway. It just needs to be able to demonstrate what it was. It doesn't need to be completely accurate. It's to demonstrate. And oftentimes demonstrative exhibits do not get admitted. Most of the times they don't get admitted, and they do not go back for the jury, but they're there to aid people in the presentation of their evidence. Well, in this particular case, this is going to get interesting. The state anticipates introducing a three-dimensional model of the 1122 King Road evidence at trial. This model will consist of 3 levels, which can be removed by level to show the interior layout of the residence. The interior layout will depict wall and door placements, i.e. no furniture, human depictions, etc. The model will be placed on a rolling table for portability within the courtroom. It can be placed out of the way when not in use. The model is being constructed by the Federal Bureau of Investigation based upon depictions, documentations, and measurements taken at the scene prior to the demolition of 1122 King Road residence. The primary purpose of this model is to aid the jury in having a better understanding of the layout of the residence, which is unconventional, and to illustrate where certain events occurred within the residence. This model will aid in certain witnesses, i.e. law enforcement, surviving roommates, individuals responding to the crime scene and crime scene analysis, in demonstrating the location of the victims, location of witnesses, locations of items of evidence, items related to the testimony, path of travel, etc. The state anticipates laying the proper foundation to establish the model accuracy reflects the layout 1122 King Road residence. The model passes the Idaho Rules of Evidence 403 balancing test, as the value is facilitating the jury in visually understanding where the facts and issues occurred in this crime scene far outweigh any danger of unfair prejudice, distraction, confusion, or waste of time. It will aid the witnesses in testimony. And the state requests the court to issue an order allowing the state to use the three-dimensional model. That's going to be an interesting presentation for sure, but they're thinking ahead. How are we best going to demonstrate this to the jury? Where do people come in? Where do people come out? What was the most likely path of travel? You could do this through photographs, but it may not give the best explanation and the visual aid to the jury. So those are a couple of the other issues, and the prosecution is asking the defense, and the other motion is the motion in limine regarding alternative perpetrator evidence, wants to prohibit the defendant from offering alternative perpetrator evidence or argument without satisfying the court that any such evidence is relevant and admissible. They go through it. The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connects other persons other than the defendant to the homicide would do nothing more than mislead and confuse the jury and would result in undue delay, waste of time. That's generally the rule. Obviously, the prosecution has to prove identity, right? They have to prove that it was Mr. Kohberger, not someone who looked like him, not someone using his identity, but it was him. And for you or the defendant to be able to say, hey, no, it was Joe Smith, right? You have to have something that actually ties Joe Smith, and you have to give notice of the alternate suspect so that you can basically let the prosecution try to disprove your theory. And also, one of the final orders was the order authorizing release of court records, the audio recording. That's right. The state shall provide the audio recording from court proceedings held in Lake Tahoe County on October 26, 2023. And that was the motion to dismiss the indictment on grounds of biased jury in regards to the grand jury, and a motion hearing regarding the motion to dismiss indictment on grounds of error in grand jury instructions. Maybe we'll see if I can track that one down. Probably have to call the court like I did last time. Anyway, there you have on the latest updates. Listen, motions in limine. You're asking for a judge to give you some boundaries, some guardrails for trial. Prosecution saying, hey, defense, you can't do this, but we're going to do this and we're going to get it cleared with the judge. So, right? And the defense saying, don't do this, judge. It's prejudicial. It far outweighs the probative value. You're going to upset my client's right to a fair trial. Judge will rule. Most of this stuff is coming in. It's subject to cross-examination, maybe some limits. Next, let's get to a little less contentious trial. That's right, the Karen Reed matter. That's right. The Karen Reed case was subject to 2 hearings in separate courthouses on Wednesday. First, Miss Reed appealed a recent decision by the Massachusetts Supreme Judicial Court at a federal court in South Boston. Once that was over, she and her attorneys headed over to Norfolk Superior Court in Dedham for another hearing. Prosecutors obviously have accused Miss Reed of hitting and killing her Boston police officer boyfriend, John O'Keefe, who she was dating at the time, and then obviously hit him with the SUV, allegedly, according to the prosecution, and then leaving him to die in the snow outside of a Canton home back in 2022. She's pled not guilty and argued that she is being framed by several people, including law enforcement involved in her investigation of the case. Now, the first trial ended in a mistrial last summer where the jury was supposedly quite divided. Her second trial is scheduled to begin in just a couple of weeks on April 1st. Like I said, so the day started in federal court where her attorneys asked the federal judge to require the state to bring back jurors from the first trial to poll them and determine if they had acquitted Miss Reed on 2 charges. The federal court seeks what they refer to as habeas, writ of habeas relief, which is a doctrine that allows people to challenge their unlawful detention. It stems from Reed's Supreme Court Judicial Court appeal, in which the highest court denied her request to drop 2 charges against her. And Reed's lawyers make 2 arguments: that a mistrial declared was not necessary and that the jurors privately voted to acquit Miss Reed. Now, the attorneys representing the state in this particular matter argued, saying that the jury verdicts in Massachusetts aren't final and can't be changed until the moment they are read out loud in open court. Therefore, there was no final verdict. I said that way back when this whole issue came up, and the appellate courts have agreed with me. That's like courtroom 101 type of knowledge. But Chief District Judge Dennis Saylor, the 4th, told the lawyers that the legal question was quite complicated, comparing it to a forest. He said he would make a decision as quickly as possible so that lawyers will have time to appeal, with Karen Reed's trial coming up on April 1st. Then, like I said, everybody after the federal court went to the state court, and there was a hearing there for the defense to argue its recently filed motion to dismiss. The hearing started off with a heated exchange with the judge scolding defense attorney, specifically Alan Jackson, before he started his argument. And the judge was referring to a part of the motion to dismiss, which was largely redacted, which apparently accused a Massachusetts state trooper of tampering with a jury. Now, the defense alleges that Lieutenant John Fanning was in charge of the jury or oversaw the jury in some capacity. Fanning works for the Norfolk County District Attorney's Office and was in a group chat in which Trooper Michael Proctor said disparaging things about Miss Karen Reed. While Lieutenant Fanning was on the text chain where Michael Proctor said he was going through my client's phone looking for nudes, according to Alan Jackson, the judge emphatically denied the allegations. What you state as fact, that Lieutenant Fanning had control or access to this jury, is simply not true, Mr. Jackson, the judge told him, referencing prior conversations regarding candor to the court. The judge also said that it's the court's offices only who are tasked with overseeing the jury. Jackson said his team, other than taking the word of the court, had no factual basis that the information that Lieutenant Fanning had no interaction with the jury was true. So what's the big deal? Well, the defense says that Lieutenant Fanning was the person who reported to the court alleged misconduct by potential Karen Reed friendly jurors, causing her to get dismissed from the case on the last day of the trial. We'll see. There's no evidence to support that, and that will probably be denied. I mean, you can make any allegation you want. It's like you can sue anyone for anything you want, but eventually you got to prove it, and you have to come forth with evidence, not just a simple allegation. Then we got the video. Now, the other major factor in Jackson's argument was that the prosecutors slowly released the Canton Police Sally Port and surveillance video to defense attorneys over years, despite having access to it the day of the alleged crime. Now, some videos were released to the defense as recently as last week. The defense says these videos are exculpatory because they have the possibility of showing the condition of the taillight of Karen Reed's SUV in the hours following John O'Keefe's death. Now, for the Commonwealth to have these video footage for 3 years, making one question was going on with the evidence. What is going on with this evidence? Jackson said, that is bad faith. Jackson also said at one point possible evidence was transferred at the Canton Police with a note on it from the police chief that ended in the term LOL. So in response, the prosecutor, Mr. Hank Brennan, told the court that Trooper Michael Proctor had gathered the video and had not passed it on to prosecutors. Brennan also argued that the condition of Reed's taillight didn't matter, showing various videos to the court where he says it is undisputed that parts of Reed's taillight were already missing, and to attempt to dispute the defense allegations that Proctor damaged Reed's taillight and therefore then planted evidence at the scene to get Miss Reed. And then, of course, to complicate everything, another juror speaks out. Another juror has spoken out with their reaction to the hearing. Now, Victoria George was an attorney herself and an alternate juror in the Reed case, and she sent a statement to one of the local news channels there. I was fair-minded as a juror who left this trial questioning the system's integrity long before the defense filed a motion to dismiss with allegations of jury tampering. The Reed case itself and the fact that it's still being brought has left many in Massachusetts wary, distrustful, and scared of the system. The reality saddens me even more as a lawyer because I remember how much faith I had in our system and as an optimistic law student. Mr. Brennan made an impassioned argument today regarding his alleged concern that some might be questioning the fabric of our entire judicial system. If you truly would like to address the problem, I have a few suggestions, she noted. Perhaps the district attorney's office should be more focused on remedying the systemic issues plaguing it and affiliated police departments rather than continuing to spend millions of taxpayers' dollars prosecuting a case with so many evidentiary issues that it calls into question whether they have even followed their ethical obligations as prosecutors. The Commonwealth has a duty to protect the defendant's rights, and I, for one, would love to see them do so. I wonder who she was going to vote for if she was the alternate that was selected to testify. Listen, I get it. There's things that go on. Everyone is shocked by what takes place here. It's nothing unusual. This garbage goes on all the time. Prosecutors say, oh, I thought I turned it over. We thought it is. In today's age of so much discovery, Judge, we thought we turned everything over. It got saved to a hard drive. We didn't know about it. There was nothing bad faith about it. Your remedy is you want a continuance, you get a continuance. That's what the remedy is more than likely going to be. People who don't work in this system know that this happens all the time, or they don't know. People that don't work in this system, judicial system like this every day, are shocked by this. This happens all the time. And prosecutors get a pass. The defense raises issues. They're looked on as bad guys, right? But unfortunately, it will continue. All right. But it's because of defense attorneys out there saying, Judge, you can't do that. Judge, they didn't turn it over. Yes, there is bad faith. I mean, I've recently seen 2 cases dismissed here in the state of Colorado when prosecutors failed to turn over evidence that had been requested, asked for, and the state had, and it was their obligation to turn over. And they said, oops, I thought we turned it over. Judge said, nope. So this happens all the time. Now, does it ruin your faith in the judicial system? It shouldn't. All right. Let me tell you why. There's a quote that says, the American judicial system is absolutely terrible, but it's better than anywhere else in the world. Now, I know some people say, no, my system in what other country is better. Okay. But we have an adversarial system. Somebody makes an allegation. The other side says, that's not true. Let me tell you why it's not true. Or they say, well, it's kind of true, or it is true. But through that adversarial system, the truth comes out. It's when you don't allow that to take place. Let the jury decide. The jury could say pox on both your houses and find her not guilty. We think you're unethical, Mr. Jackson, and we think the prosecution is unethical as well. Something to think about. All right. So what are we going to do next? There's still 2 motions to argue in this case, plus some more motions in limine, obviously regarding evidentiary issues ahead of trial, which means, guess what? They're going to be back in court on March 18th. The judge will also make a decision on a number of outstanding motions at that point, if not before then, if she issues a written order. I said it yesterday and I'll say it again, or the other day I said it, that this is turning into like an O.J. Simpson case. This is a maybe 7-day trial. This is maybe a half a day or 1 day of argument on motions, and that's it. This judge, Cannon, whatever her name is, however you pronounce it, doesn't really matter. The judge, she's turned into the Judge Ito of the O.J. Simpson case. Has no control, and just seems like it's dragging on and on. Anyway, and so then a final recap. Obviously, Miss Reed is charged with second-degree murder, manslaughter, while operating under the influence of alcohol and leaving the scene of a personal injury and or death. Her trial begins April 1st. Next, let's not let this woman have any knives around if she is going to have somebody break up with her. So a California woman suspected of killing her fire captain wife allegedly sent her friend a text message just the day after the firefighter was found stabbed inside her home. Now, police have issued an arrest warrant for Yolanda Marotti, accusing her of fatally stabbing her wife, fire captain Rebecca Marotti, inside their home in California back on February 17th. Now, the fire captain was found inside the house suffering from multiple stab wounds to her neck, chest, and abdomen, and was pronounced dead at the scene while, guess what? Her spouse was nowhere to be found. But guess what? A day later, Yolanda, who is also known as Yolanda Olajek, texted a friend asking her what had happened. Becky came home and told me that she was leaving me. She met someone else. All the messages were lies. She replied, according to the warrant. Well, then there was a big fight, and I hurt her. I'm really sorry. It's now believed that Yolanda repeatedly stabbed her wife hours in the midst of an argument before the body was then found. And guess what? She fled to Mexico. Now there's video footage from the home that shows Yolanda apparently chasing Rebecca across the patio about 8 p.m. And you can hear a voice believed to be Rebecca can heard be crying out, "Yolanda, please, I don't want to die," before she appeared in the frame with what appears to be blood running down her neck. At that point, another voice believed to be Yolanda could be heard replying, "You should have thought about that before," as she stood over her wife holding a knife with an apparent blood on her arm. Now, Rebecca repeatedly told her wife to call 911 while Yolanda demanded she go back inside, an order the fire captain eventually obeyed as the two were seen entering the home. It was the last time Rebecca was seen in the footage. About 10 minutes later, Yolanda is seen gathering pets, random items, and some luggage and leaving in her Chevy Equinox. She was also seen wearing different clothes during what appeared to be a rushed escape. The vehicle was caught hours later entering into Mexico, according to Homeland Security, and at that time, Yolanda's whereabouts are not known. Now, out of an abundance of caution, the sheriff's department has alerted both sides of law enforcement on both sides of the border to be on the lookout for the suspect, and is now urging the public to be on the lookout for her Equinox as well. Now, Yolanda is 5 foot 2 inches tall, weighs about 165 pounds, brown hair, and has tattoos on both of her upper arms. But this is where it gets interesting. Guess what? Nearly 25 years ago, Yolanda fatally stabbed her then husband, James, as the two were getting divorced. In 2003, she pled guilty to voluntary manslaughter, sentenced to 11 years in state prison the following year, and was only released from custody in 2013. That's right, ladies and gentlemen. Keep the knives away from her. She's not going to be working in the kitchen, to say the least, if she goes to prison, because obviously we give her the presumption of innocence. Next, distribute drugs, people die, go to prison. That's usually the way it works. So 3 men died more than a year ago when they were found in the backyard of a back porch the night Kansas City Chiefs football game. Clayton McGenry, Ricky Johnson, and David Harrington were found dead in a house in Kansas City. Well, the Platte County prosecuting attorney Eric Zand charged Jordan Willis and Ivory Carson with delivering a controlled substance, 2 counts, involuntary manslaughter, 3 counts. A probable cause affidavit indicates that McGenry, Johnson, and Harrington died from a combined toxicity of fentanyl and cocaine. It lists off statements and evidence collected over the course of the year as follows. A witness described partying with Willis and the others at Harrington's home before they left the house. Witness number 2 observed a large plate with anywhere from 1/2 ounce to an ounce of blow, referring to cocaine, which was supplied by Willis, and everyone present was using the cocaine. Witness number 2 stated Willis was the only person in the group who could find and purchase that amount of cocaine. Another witness said the friends wanted to party and ran low on money, and they would hang out with Willis because he would provide the drugs. Now, an attorney who represents Mr. Willis has stated that Mr. Willis had nothing to do with the deaths, and he said that his client is unaware of how his friends died. Like the rest of us, his client is anxious and awaits the results of the autopsy and toxicology reports. And on behalf of his client and his family, we wish to express our deepest sympathies to the friends and family members of these young men, and our thoughts and prayers go out with all of them. Well, Willis allowed officers to search his house when they arrived at the front door, and the attorney said that Mr. Willis's friends parked their cars on the street and didn't even see them until after the police arrived. Now, the probable cause affidavit indicates 2 bags found in the home were tested for narcotics. One was determined to be cocaine, the other fentanyl. DNA results later described Willis as a major contributor of DNA on the bag of cocaine, and Carson as a major contributor as well of DNA on the bag of fentanyl. Cell phone data was also extracted from Harrington's phone, showing messages between the group. The messages showed the main source of supply of cocaine for Harrington was Carson. Well, the prosecutors there held a news conference the other day. They announced the charges and said that they hoped the charges send a serious message about consequences to those who continue to bring other dangerous drugs in our community. Know that if you are distributing those drugs and you cause harm, you will be arrested and you will be charged. The prosecutor also know that they have not yet determined whether the men were aware that there was actually fentanyl in the cocaine. 3 men are dead because of the dangerous street drug, and he urged everyone thinking about buying or doing drugs on the street to think twice before they do it. Anyway, Mr. Willis's and Miss Carson's bonds are set at $100,000. Dangerous out there, ladies and gentlemen. You don't know what's in any street drug. They add this as filler. The drug dealers don't care. I was at a very interesting luncheon the other day that had people from the main office from DEA, and it is poison. And someone says, well, why would these people poison their customers? Because they don't care. Their goal is always get new customers. And if a couple people die, they just don't care. You got to be super careful out there, ladies and gentlemen. And having done trials of distribution of resulting in death, I can tell you, it also gets you like a 30-year sentence in federal prison. Next, Officer Sexy has been arrested, and guess for what? A New Hampshire police officer is facing child sex abuse charges regarding images after an investigation linked him to some graphic uploads and disturbing conversations on a messaging app, according to the Internet Crimes Against Children's Task Force. Now, working off a tip from the National Center for Missing and Exploited Children in Massachusetts, police issued a warrant for John Giarrusso, 48, after it was determined that his IP address and social media accounts linked to his name and date of birth were used in sending and receiving graphic messages about having with children as young as 6. Yeah. Anyway, former Officer Giarrusso is also accused of uploading several videos to the messaging app Kik that show children being molested and by adults, according to the criminal complaint. He's also engaged in graphic conversations with other Kik users about arranging to have sex with their wives, young daughters, and stepdaughters. In some conversations, it is alleged that Giarrusso, Seabrook, New Hampshire police officer, brags to other Kik users about his job and says the girls in town call him Officer Sexy. Well, the investigators say the investigation found his role as a police officer, and he also participated in fundraising for child-focused facilities that helps abused children heal by coordinating the investigation and treatment of child sexual abuse. Investigators said selfies uploaded to Kik verify his identification on the app, as well as other users during the illicit conversations that were confirmed to be Giarrusso. Now, Giarrusso is charged with possession of child abuse images, dissemination of visual materials of a child in a state of nudity and sexual conduct, disseminating obscene matters to a minor. Ugh, just gives you that ick, doesn't it? 48-year-old dude trying to have sex with a child, 6 years old. Just saying. Be careful who is around your children. Next, this day in legal history. On March 6, 1857, the Dred Scott v. Sanford decision. That's right. The Supreme Court ruled that Dred Scott, an enslaved person, was not an American citizen and therefore couldn't sue for his freedom in federal court. Obviously, that decision also stated that slavery could not be banned in federal territories, escalating tensions that led to the Civil War. And on this date in 1978, Larry Flint, publisher of the Hustler magazine, was shot and paralyzed by a sniper in Lawrenceville, Georgia. Obviously, it highlighted tensions surrounding the First Amendment and the rights of obscenity laws in the United States. And on this date in 1981, President Ronald Reagan announced a comprehensive plan to reduce the federal regulations in the government, aiming to stimulate economic growth. The initiative led to significant deregulation in various industries, impacting labor laws, environmental policies, and financial regulations. And on this date, March 6, 1998, the United States Supreme Court hears Clinton v. New York. Supreme Court heard argument in that case, challenging the constitutionality of the line item veto. The court's decision invalidated the line item veto, reinforcing the separations of powers doctrine. Congress passes the law saying you must spend the money on this, then you got to spend the money. They couldn't go through and just strike it and say, I think that's ridiculous. Interesting. Separations of powers issues. Looks like they're coming back again today, too. We'll have to wait and see who has the power. But just because they give the money to the executive branch doesn't mean they have to spend it. And finally, our dumb criminal of the day. A Florida woman reportedly stabbed her boyfriend because he wouldn't eat her cooking. Gents, always eat the food, all right? If your girlfriend cooks you a meal, it's probably best you eat it. Then not only do you have to eat it, but you better like it. And if you show any signs of not liking it, you might be in trouble, or she might hurt your feelings, and you don't want that either, right? Now, some people will handle it differently than others. Some will cry, maybe be upset, never eat the food again, right? Others will go on the attack. Well, that's what this Florida woman did. Nativia Augusta was hiding in the bushes when the police arrived to their neighborhood. Now, the victim informed police that what had just happened, and he believed it was because he didn't want to eat her food. Anyway, a witness was able to call 911 during the attack, and needless to say, Miss Auguste was brought into custody without incident. The victim only had to get a couple of stitches and treat his injuries. Now, I hope he doesn't go back to Mr. Auguste, but my advice would be, sir, eat the freaking food, all right? Maybe even give a compliment. That's all we have for you today, ladies and gentlemen. Hope you enjoyed the show. We'll see you next time on Crime Talk.